because he is seeking to set aside the entire judgment of the Court of Appeal and uphold the judgment of the High Court. So he is opposing the appeal. For the sake of orderly flow of the proceedings, we will request the respondents who are supporting the first and second appellant to go first, and then the third appellant will start before the respondents take the floor. So we have the Speaker of the National Assembly.
Will come to her later. According to this order, she's 13, 14, 16. Then she comes.
Yes.
My lady, if you may please you in the matter, my name is Kuyuni. I appear with Mr. Mbarak Awad for the Speaker of the National Assembly and the 13th respondent, and the National Assembly, the 15th respondent. My lady, I would like to place on record, my lord, the documents we have filed on behalf, my lady, of the National Assembly and the Speaker of the National Assembly. And my lord and my ladies, we have filed submissions, and the submissions are dated the 14th day of December 2021. At the outset, my lady and my lords, we would like to state that we are supporting the appeals by the first appellant and the appeal by the second appellant. And my lady, we admit that it has a basic structure. My Lord, I will also address you on the extent if the basic structure doctrine limits the power of amendment. And my question, my lords and my ladies, to that question, my answer to that question is that it does not limit the power of amendments. The Constitution, chapter 16, is self-contained. It's self-executing. It has provisions on how to amend each and every article of the Constitution. And therefore, there is no need at all of invoking the basic structure doctrine. In any case, my lords and my ladies, the Constitution itself, under Article 255, already provides safety valves on the amendments through the parliamentary initiative. That is also a reason why the basic structure doctrine is not applicable. Our submissions, therefore, is that the power of the people to amend the Constitution flows directly from the Constitution itself, specifically Article 1, Sub-Article 1 and 2 of the Constitution. That right, my lords and my ladies, cannot be limited, either by the court or even the Constitution itself, my lord. The people are supreme, much more supreme, my lord, than the Constitution itself. What the High Court of Appeal and High Court judgments did is placing the Constitution above the people that it's supposed to govern. My lord, that we come before you, my lord, asking you to correct that error by the superior courts. My lords and my lady, the second issue that we would like to address you on is whether the president can initiate changes and amendments to the Constitution. My lord, we have read the Constitution, specifically Article 255 to 257. We have not found any constitutional backing or foundation to the finding of the court that the president or any other state official is precluded or discriminated from initiating amendments to the Constitution. And therefore, my lord, it's our submission that it's not prohibited in the Constitution. And if it's not prohibited, my lord and my ladies, then it is allowed. That is, my lord, our submissions on the second issue. My lord, just to add to that, my lord, the president, a person being elected president does not lose any rights that he had before. And I will refer you, my lord, to Article 137, 1A and C of the qualification on the qualifications for election of a president. And one of the qualifications is the president must be a citizen of the country. At what point, my lord and my lady, does he lose that right, such that he can initiate constitutional amendments? My third issue, my lord and my lady, is the place of public participation in respect of the Constitutional Amendment Bill 2020. Public participation, my lords and my lady, is a very paramount element of our Constitution. It's provided in Article 10, 118, and almost every other article of the Constitution, including Article 257. My lord, public participation in respect of the Constitution of Amendment Bill is a continuous process. And it starts, my lords and my ladies, from the collection of the 1 million signatures. You start engaging the public from the day you go back to to them and asking them to sign the document. It then proceeds to the county assemblies, and county assemblies are obligated to also conduct public participation. And if the county assemblies pass the bills, it goes to parliament, and parliament again are also supposed to conduct public participation. And on behalf of the National Assembly, I do confirm that public participation was extensively carried out, especially by parliament in respect of the Constitution of Amendment Bill 2020. And therefore, my lords and my ladies, public participation in a constitutional amendment is not a single day event. It's a continuous process that starts from the collection of signatures and ends at the referendum stage. It is therefore wrong to look at public participation as a single event and isolate it, my lords and my ladies, from what has been done before the bill is presented to the public. And my lords and my ladies, a last issue, I'm just trying to run through the issues, my lords and my ladies, because most of the issues have been submitted on, is whether the interpretation of Article 257.10 of the Constitution entails and requires that all proposed amendments to the Constitution should be submitted as separate and distinct referendum questions. My Lord, we submit that the third appellant, my Lord, who is the proponent of that suggestion, is wrong. Article 257.10 does not require all specific proposed amendments to be submitted as separate and distinct referendum questions. Both Article 256 on parliamentary initiative, 257 on popular initiative, make reference to a bill that is either approved or rejected. There is no requirement at all for separate and distinct referendum questions. And therefore, my lords and my lady, we submit that the Constitution itself does not speak about distinct and separate referendum questions. It speaks about a bill. Therefore, my lords and my lady, we ask you to uphold the ruling of the Court of Appeal to that effect, that there is no requirement for separate and distinct referendum questions. For those few remarks, my lords and my ladies, we wish to urge you to allow the appeals by the first and second respondents and dismiss the appeal by the third respondent. I note that I still have around 6 minutes, my lord. I would like to donate them to my colleague for the Senate, Mr. Ambulo. Thank you, my lord.
The Honorable Chief Justice, your Lordship and your Lordships, my name is Job Wambulwa. I appear together with Ms. Mercy Tanji for the Senate and the Speaker of the Senate, who are the 14th and the 16th respondents in these consolidated appeals. From the onset, your Lordship and Lordships, we wish to associate ourselves with the submissions made by the Attorney General, the IEBC, and my friend Mr. Kuyoni, and other respondents that will submit in support of the two appeals. We will be submitting on 4 issues. And the first issue that will be, before we submit all the issues, we filed our submissions are dated 10 December 2021. And the first issue that we should be submitting on is the issue of applicability of the basic structure doctrine in Kenya. And my lord and my ladies, when you look at the judgment of the Court of Appeal, the court upheld the finding of the High Court that the basic structure doctrine is applicable in Kenya, and that the same doctrine limits the amendment powers under Articles 255 to 257, and that the same can only be amended, can only be altered through the primary constituent powers, which must include the 4 sequential steps of civic education, public participation, and collection of views, constituent assembly, and ultimately a referendum. The import of that finding, my lords and my ladies, is that the court elevated our constitution to the level of a holy book. We believe that it's only a holy book that cannot be amended, cannot be changed. We have to believe what is there and trust what is there. When you look at that and look at how this doctrine has been applied in other jurisdictions, starting from India, in the Kesavananda case, in the Minerva Mills case, and so on, you'll find that first, this case, this doctrine was, in the jurisdictions where it has been applied, was mostly concerned with limiting Parliament power to amend the Constitution. And also to note that in most of those jurisdictions, just like in our previous Constitution, Parliament had unlimited powers to amend any part of the Constitution, and their powers to amendment were limited. Therefore, it was very important for the courts to come in and limit, or at least protect, the basic tenets of the Constitution. That cannot be said to be the case with our Kenyan Constitution. Looking at the history of Kenya, the framers of the Constitution were aware of those challenges that were there, the abuse that was there, and indeed, the Parliament's power is now so much limited when it comes to amendment of the Constitution. Another issue that arises out of this is that you'll find that this doctrine itself has even received mixed receptions all over the world. There are those countries which jurisdictions have accepted this doctrine. There are those ones which have rejected it. And even amongst the legal and academic scholars, as you'll see from the Amish briefs that are before you, that they do not even agree amongst themselves. There are those who urge caution in the applicability and reception of that doctrine. There are those who say that this doctrine is applicable. That indicates that this is a raging debate. This is not a settled debate. Therefore, experimenting and the way the Court of Appeal, with due respect, applied that doctrine poses various challenges going forward for our country. In this regard, therefore, we submit that although our Kenyan Constitution has a basic structure that has been identified under Article 255(1) with entrenched provisions or thematic areas, that before you amend those areas, you must go through the people. Because under Article 1, the people are supreme. They're sovereign. And that sovereignty, therefore, where you want to amend those aspects which Kenyans consider to be core, you have to go back to the people for approval. We therefore submit that the basic structure doctrine is not applicable in Kenya, but the Kenyan Constitution has a basic structure that can be identified from Article 255(1). The same cannot be inferred. It is provided for in the Constitution. As to whether the basic structure of our Constitution can only be altered through the primary constituent powers, we disagree, humbly disagree with the finding of the superior courts in this regard, because the court gave us 4 sequential steps that we have to follow for we to amend what was considered as a basic structure. And there lies a problem. When you look at these 4 steps, and first of all by looking at the primary constituent powers, and looking at going through the civic education, public participation and collation of views, constituent assembly and debate, and also a referendum, you'll find that even our own constitution we are having now, the said processes were not followed because they are equated. Professor Rosnai, I think, defines constituent's power to mean power to constitute a constitution, to form, making a constitution. Therefore, the same steps that are used to make a constitution, what the court is telling us that you have to follow the same steps when you want to amend a basic structure of the constitution. And this case, while these arguments are good and raises very important academic debates, the same poses challenges. And these challenges are, one, that it is very difficult, based on the judgment of the Court of Appeal, to identify specifically what a basic structure is of our Constitution. And if you cannot be able to identify, that will mean that whenever anyone will want to amend the Constitution, what do? Maybe you rush to court and ask the court, I want to amend this aspect of the Constitution. Does it concern a basic structure? Secondly, even as I've mentioned before, that even our own Constitution that we are having now, we are trying to protect, that it did not go through the said processes. And amendments to the Constitution are necessary to respond to situations or changing circumstances in every jurisdiction. Therefore, by including a whole chapter on amendment of the Constitution, it was not by default, it was not by mistake. That therefore you include a whole chapter in the Constitution, then you tell the people that, you know what, you cannot amend what we consider as a basic structure. You can only use these processes under Chapter 16, probably to correct some errors or some minor issues. And this process includes even collecting 1 million signatures, going to the people to vote in a referendum, probably spending millions and millions of Kenyan money only to correct maybe some errors or a few issues in the Constitution. I don't think that was the intention of the framers of the Constitution. We submit, my lords and my ladies, that Article 255 and the Constitution in general, when you look at the amendment powers under Chapter 16, that it has inbuilt safeguards against abuse or against hyper amendments. And this, therefore, the court erred in introducing some other safeguards that were not contemplated in the Constitution. And therefore, when you look at the failed attempt since the 2010 Constitution was promulgated, we've had about more than 20 attempts to amend the Constitution, both through parliamentary initiative and also through popular initiative. That indicates that the Constitution itself can protect itself. We do not need any other measures outside what is provided for in the Constitution for we to protect the Constitution. And further, we submit that there is no provision. When you look at Article Chapter 16 of the Constitution, there is no provision in our Constitution that is out of reach of the amendment powers of the Constitution, provided the procedure laid down in the Constitution has been followed. People have sovereign power running through from the preamble, Article 1, that they have the sovereign power to decide how they want to be governed, to decide the form of governance they want to take, so on. Therefore, on this issue, we conclude by saying that if indeed the framers of the Constitution could have intended to limit that article, to limit the amendment powers, that will make some articles of the Constitution, some aspect of the Constitution to be unamendable, we think that they would have provided so in the Constitution. In summary, we submit, therefore, that the basic structure doctrine is not applicable in Kenya. 2, that the Constitution of Kenya has a basic structure that has been identified by thematic areas in Article 255(1). 3, that Chapter 16 of the Constitution has no express unamendable, or the Constitution as a whole has no express unamendable provisions. And finally, that there is no implied limitation to amendment powers under Chapter 16 or in the Constitution. The second issue that I will briefly highlight is as to whether the President can initiate changes or amendments to the Constitution, and whether a constitutional amendment can only be initiated through Parliament under Article 256 or through a popular initiative under Article 257. From the onset, we submit that the Constitution has no preclusion for any person, body, be it public, private, or a class of people, to promote constitutional amendment through a popular initiative, provided the procedure that has been laid down under Article 257 has been met. The only requirement we find under Article 257 is that the promoter has to get support of 1 million signatures. Secondly, there is no provision that supports the finding that state actors be limited to the use of the parliamentary initiative route and non-state actors to use popular initiative route. Every person can use a popular initiative route to amend the Constitution, and at the same time, every citizen, as provided for under Article 119 of the Constitution, can petition Parliament to consider any matter within its mandate, including amendment to the Constitution. Therefore, nothing even stops common citizenry from petitioning Parliament to deal with amendments to the Constitution. At the same time, there is no guarantee that when Parliament will always accede to your request. They might consider your request for amendment and reject it. And even the executive, you bring a bill to amend the Constitution and the Parliament has that mandate, they will consider it and might agree with you or might disagree with you and reject that proposal. Therefore, it is our submission that the Constitution introduced popular initiative route, not to limit it to the common citizenry, but to guard against the monopoly of Parliament on constitutional amendments. The Speaker of the Senate and the Senate therefore rightly submit that the right of amendment by popular initiative under Article 257 of the Constitution is open to any person, including the President, including politicians, including public servants, and the common public. And we find that, humbly find that the interpretation of Article 256 and 257 on popular initiative runs contra to what Article 259 provides, which obligates the Constitution to be interpreted in a manner that promotes its purpose, values, and principles, and also to advance the rule of law, human rights, fundamental freedoms, and permit the development of law and to contribute to good governance. On the third issue, as to whether the place of public participation under Article 10 vis-a-vis the role of IEBC under Article 257(4) of the Constitution, and whether there was public participation in respect to the Constitution of Kenya Amendment Bill 2020, we submit that Article 10 obligates or makes a public participation a value and a principle of governance. When you consider Article 118(1)(b), it imposes an obligation on Parliament to facilitate public participation and involvement of the people in all its legislative and other businesses. The same applies to county assemblies under Article 196(1)(b), which imposes, which requires that there shall be public participation at the county level. When you look at Article 257, it's framed in a manner that ensures public participation runs through every stage of amendment through a popular initiative. This starts with collection of 1 million signatures. We believe that before you collect 1 million signatures, 1 million people should be aware of why they are giving their signatures for. Secondly, when the bill is submitted to IEBC and the IEBC takes that bill to the county assemblies, they are obligated to carry out public participation under Article 196(1)(b). The same applies when it comes to Parliament. Under Article 118 and also Article 256, it requires Parliament to carry out public participation. And ultimately, when this bill goes to the people in a referendum, the people will participate. We therefore submit that the participation of the public in a constitutional amendment through popular initiative is a continuous process. It's not a single event that should be looked at in isolation of other stages. In this regard, we find or we submit humbly that the Constitution should be interpreted holistically and purposefully by looking at public participation as involving all these stages. And therefore, as to whether there was public participation in respect to the Constitutional Amendment Bill 2020, the same can only be determined by interrogating all the stages of public participation in amendment process through a popular initiative. The last point that I wish to submit on is with regards to the issue raised by the third appellant, Mr. Moraro Omoke, as to whether interpretation of Article 257(10) of the Constitution entails and or requires that all proposed amendments to the Constitution should be submitted as separate and distinct referenda questions. From the onset, we oppose the petitioner's assertion and submit that the learned judges of the Court of Appeal did not err in holding that Article 257(10) of the Constitution does not require specific proposed amendments to the Constitution to be submitted as separate and distinct referendum questions to the people. Why do we say so? When you look at Article 256 and 257, your lordships and your ladyship, on popular initiative, it makes reference to a bill that is either approved or rejected by Parliament, and depending on on the subject being amended, submitted to IEBC, to the President and to IEBC to hold a national referendum for the approval of the bill. In particular, when you look at Article 256, 5A, it clearly states that if a bill to amend this constitution proposes an amendment relating to a matter specified in 255(1), the president shall, before sending to the bill, request the Independent Electoral Boundaries Commission to conduct within 90 days a national referendum for the approval of the bill. It doesn't talk about a question. It talks about approval of the bill. In this case, therefore, we find or we submit that there is no requirement for separate referenda, separate and distinct referenda questions, and the learned judges of the Court of Appeal clearly interpreted Article 257(10). In summary, therefore, we urge this Honorable Court to correct the error submitted by the Court of Appeal and the High Court, and uphold the prayers by the Attorney General and by the IBC, and to dismiss the appeal by Mr. Moraro Moke. On the remaining issues that we did not submit on, we associate ourselves with the submissions made by the AG, Attorney General, and the IBC and other respondents that we be supporting their appeals. I wish to rest there, my lords and my ladies. Thank you. The remaining 5 minutes, my lord and my ladies, I'll donate to the Honorable Attorney General in their rejoinder.
Okay.
Okay. Next, from our own lists, we find like the 17th respondent is supporting the appeal by the first and second appellants. Are we correct? If not, there is the 19th, or whoever is supporting can take the floor.
Submissions for the 18th and 21st respondents. I shall be submitting with Mr. Jackson Awele and Mr. Arnold Ocheng, but our senior, Mr. James Orengo, will want to make a closing remark after those three presentations. We shall share the 30 minutes. I will ask then, when I'm ready to hand over to the next presenter, then that the clock be stopped then. My lady, my lords, I will begin first by wanting, in our view, to characterize how we view the basic structure doctrine. And I want to use the words of Justice Barrow in the case of Richardson versus Mellish, an old case of 1824. And the words I would use to describe the basic structure doctrine is that it is a very unruly horse, and once you get astride, you will never know where it is going to carry you. And I want to give the reasons why we view the basic structure doctrine as a very unruly horse. One, this doctrine does not have any agreed on jurisprudence. It began as a theory by a German philosopher, Dietrich Conrad, and this is way before it was picked up by the Supreme Court in India. But even when it was picked up by the Supreme Court in India, it was employed for purposes of reading limitations to the power of amendment of the Indian Parliament. But if you look at the way it is argued today by the New Age philosophers, the Yaniv Rosnai and the rest, it has looked more as upholding some parts of the Constitution as sacrosanct. So one of the things then one does, is there a universal jurisprudence that one can say you are following whenever you are employing the basic structure doctrine? And our submission is that the basic structure doctrine is too many things to too many people. It depends very much always on who wants to use it. and in this case, it's a horse that will take you only where sometimes to where you don't want it to go. In Kenya, when it was employed, it is taken beyond the way it was in Kasavananda, and is now a limitation to the overall powers of amendment under Chapter 16. So in Kenya, it goes beyond targeting parliament, it goes beyond targeting county assemblies, and becomes an overall limitation, meaning that then we have to start looking at some parts of the Kenya Constitution as sacrosanct and not open to amendment regardless of the institution. But that then brings the second question, which was also faced by the High Court. Is there any agreement, any universal agreement today as to what are the basic, what are things that are basic about a constitution? The world has agreed on particular constitutional rights. We have Universal Declaration of Human Rights, we have declarations of economic, social, and political rights. The fact that we have agreed on that, are they basic structure to everybody? Is there a requirement in law, in international constitutional jurisprudence, that these rights, because they are agreed on at the United Nations, are rights that must be protected? So, and when the High Court was asked what the basic structure of the Kenyan Constitution is, it wasn't able to answer that. In fact, if you read the judgment, they seem to almost say that the basic structure is everything in the Constitution, because the judge said that it extends from Chapter 1 to Chapter 18. So throughout every place where this doctrine has been employed, nobody has been able to agree on what universally can be determined to be basic structure and what is being protected. Which then brings in the third thing. Does basic structure come by the very existence of a constitution? So for instance, the American Constitution started off without a Bill of Rights. Did it have a basic structure then, or did it acquire a basic structure when it got its Bill of Rights? Do the constitutions of China, of Iran, of Russia, of Saudi Arabia, do they have basic structures? Or do we have to first identify a particular kind of constitution which has particular elements to it, which we then say that we are now going to apply basic structure doctrine because you now have the kind of constitution that can be said to have basic structure. And so that we are able then to set aside these constitutions that we believe promote constitutionalism and human rights, and also be set aside other constitutions that we possibly must view as being substandard, and decide then that basic structure only applies to particular constitutions, because otherwise we would have to go and say that the Constitution of Saudi Arabia has a basic structure. And if that is so, then what is that basic structure? Is it those rights that we agreed at the United Nations? And I'm still making the point of how nebulous this doctrine is, how it applies. No laws apply to it. It is all over the place. But if you compare this with possibly Hans Kelsen's theory of, for instance, Grundnorm, there's a kind of an attempt to have an objective test of how you can identify when there has been a Grundnorm. And that test has even been universally, in all the cases that his theories have been put up, you can see the similar tests being applied to determine something. The cases of Ex parte Matovu, the cases of Landerberg, you see the same test being applied from the sayings of a philosopher and being able to reach an end, a decision. I do not know how much of that you can say about basic structure doctrine. What are these tests? What are the objective tests and the objective rules that one can use on it? Now, you get the same problem then also when you go to dealing with primary constituent power and secondary constituent power. And these terms seem to suggest that people's sovereignty does acquire some subordinate status depending on how it is used. So that they say that once you have made a constitution, then you leave your primary constituent power. You kind of are left with some subordinate sovereignty. I do not think people's sovereignty can be judged in that way. But first, it begins from the point of assuming that there is a way, an accepted way, a best practice as to how constitutions come into being. And you see that throughout the High Court and the Court of Appeal in these cases. The talk of the Constituent Assembly, the talk is as if there's an agreed way in which constitutions may come. But we've seen constitutions come all over the world, brought even by military regimes, constitutions brought in by coup d'etats, constitutions brought in after civil wars. So there is no agreed way that a constitution in the world comes into being. So at what point then do we start talking about Constituent Assembly? And even if you go to the arguments about Constituent Assembly, there's no agreed, actually even an agreed acceptance of what a Constituent Assembly is. There are countries where it is parliaments that have reconstituted themselves as constituent assemblies. So when the High Court says that Kenya must start by first constituting a constituent assembly, what does that mean? And how shall we convene this constituent assembly? Shall we elect it? Is it going to be a delegate system? Are they going to be appointed by parliament? Because those are rules that have not been agreed on. And if you even try to make the holding of Constituent Assembly to be the best practice, then we are going to have to totally review also theories like those of Hans Kelsen, who says, how do you tell whether a constitution is good or not? His answer to that is purely political. He does not answer it from the basis that this constitution came in through the Constituent Assembly. He only asks the question whether the constitution is in control, whether it is efficacious, and whether it has a grundnorm. And once you answer those political questions to Hans Kelsen, then you have a constitution. So how do we play this basic structure doctrine in the light of all the other constitutional theories that there are? So lastly, all I want to say is that we must warn ourselves against the romanticism of the jurisprudence in basic structure doctrine. And as a philosophy, it's very alluring. When you read it, it's very charming, it's very enchanting. But the more you read it, the more you realize what kind of chaos it can cause to a constitutional order. And that is why we are warning that it is an unruly horse, and we do not know where this country is going to take this country if this country remains astride this philosophy. And for that reason, it is our prayer that your lordships will lift this country from the saddle of this horse and avoid the chaos that it can bring to our jurisprudence. Thank you.
My Lady the Chief Justice, my Lady the Deputy Chief Justice, my Lords, and my Lady, Justices of the Supreme Court. My role today will be to highlight to you the salient issues that arise in our written submissions with respect to issues number 2 and number 3 in the list of issues
Your
as
name,
settled.
please, for sake of recording.
I beg your pardon? My
Your
name?
Yeah, for sake of
My
recording.
apologies. My name is Jackson Awele for the 18th and 21st respondents. My Lords, with respect to the first issue, and that is the question of whether the President can initiate changes or amendments to the Constitution, and this issue is two-pronged. The second issue or sub-issue arising therein is whether a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution. Our very brief answer to both those questions is that yes, my Lords, the President can initiate changes or amendments to the Constitution, and that indeed a constitutional amendment may be initiated by Parliament via Articles 256 and 257 of the Constitution, and we venture to add that the same may be initiated by any person. We say so for the following reasons, my Lord. The Constitution of Kenya recognizes 3 ways of amending it. One is by popular initiative via the Articles 255, as read with Article 257 of the Constitution. The second is through parliamentary initiative via the Articles 256(1) of the Constitution. And the third is a somewhat hybrid parliamentary stroke popular initiative specifically provided for under Article 256(5) of the Constitution. Who can initiate an amendment by popular initiative and how to do so is clearly defined under Article 257 and is identified simply as a promoter. No further or other definition, my lords, is proffered under the Constitution or indeed any other law as to who a promoter is or is not. In essence, we submit that who a promoter is should be permissively construed so that any person, and we lay emphasis on this, any person who can meet the procedural sequential thresholds set out under Article 257 of the Constitution, that is to say, proposes an amendment to the Constitution by the general suggestion or a draft bill and gets the said proposal signed by at least 1 million registered voters on a strict application of Article 257 of the Constitution should qualify as a promoter and would therefore be said to have initiated an amendment to the Constitution. Similarly, amendments to the Constitution by parliamentary initiative under Article 256(1) of the Constitution and under Article 256(5) of the Constitution, what I refer to as a hybrid parliamentary stroke popular initiative, are by dint of the Constitution itself not an exclusive preserve of members of Parliament or indeed any other person. This argument, my lords, finds basis in Articles 109(5) and 119(1) of the Constitution, both of which prescribe who may introduce a bill in Parliament. And Article 109(5), a member or committee of the relevant House of Parliament may introduce a bill in Parliament. Under Article 119(1) of the Constitution, every person has a right to petition Parliament to enact legislation. The long and short of that submission, my lords, is that any person, without any limitation whatsoever, may propose an amendment to the Constitution, including of an Article 255 matter, via a bill which would then be dealt with pursuant to Article 256(5) of the Constitution. In the case of the President, he will be doing so not because he is a state officer, but because he, as every other Kenyan, enjoys all the rights and privileges reserved for citizens under the Constitution of Kenya. Indeed, as rightly submitted by my learned senior, Mr. Karori, he is a president because he is a citizen first. Evidently, therefore, my lords and my ladies, there is no basis in the face of the Constitution, nor in the documented history of its making, that supports the conclusion reached by the learned judges of the High Court and the Court of Appeal to the effect that the Constitution created bifurcated tracks, one of which was intended for state officers and the other for ordinary citizens. Such a bifurcation, my lords, if cemented and or etched in our jurisprudence, portends serious absurdities that would contradict some of the very basic values and principles that underpin our constitutional architecture and design, and indeed our democracy. This, if I may give examples, would include Articles 1, 27, and 37 of the Constitution that declare the people as the sovereign, as supreme. Article 27 that declare equality of every person before the law, and Article 37 that guarantees political rights for every person, irrespective of stature. We have set out, my lords, for your benefit, these absurdities in extenso in our submissions before the Court of Appeal and in our submissions before this court, and we trust that you will have ample time to consider the same. May I add that I concur fully with the submissions of my learned senior, Mr. Karori, who set out some of these contradictions and absurdities in the event that that reasoning of the Court of Appeal is to be upheld. As a matter of fact, my lords and my ladies, if it was the intention of the drafters of the 2010 Constitution, well aware of the history of abuse of the amendment power of the Constitution under the previous Constitution by parliamentarians and the executive, that right should be limited, nothing would have been easier than for them to expressly say so. Finally, my lords, on this issue, we reiterate that much as the President had the right and indeed power to propose amendments to the Constitution by way of popular initiative, the impugned amendments were in fact initiated by Honorable Junet Mohammed and Mr. Dennis Waweru. We urge your lordships to avoid the trap that the learned judges of the High Court and Court of Appeal fell into by conflating the events preceding the proposals to amend the Constitution with the actual proposal to amend the Constitution by the Constitution Amendment Bill 2020. Yes, by the Constitution Amendment Bill 2020. Anything that preceded that bill, we submit, that proposed the contested amendments and upon which 1 million plus signatures were appended are irrelevant in our view and extraneous for purposes of evaluating compliance with Article 257 of the Constitution. With respect, therefore, the court will appreciate, and we so urge, that the findings of the learned judges of the Court of Appeal, specifically embodied in the final order number 5 of the impugned judgment, that the President cannot initiate amendments to the Constitution was premised on a grave misdirection, that the events preceding the Constitution Amendment Bill 2020 and the 1 million signatures were constitutional acts or events contemplated under Article 257 of the Constitution. Very quickly, on the second question as to whether the second schedule to the Constitution of Kenya Amendment Bill 2020 is unconstitutional, my lords, the argument that an amendment to any provision of the Constitution, let alone Article 89, can be unconstitutional merely because the same seeks to disturb the status quo cannot, in light of the broad and permissive provisions of Chapter 16 of the Constitution, stand. That argument is founded on the erroneous and very absurd proposition that Article 89 of the Constitution is unamendable and cannot be disturbed, not even by the sovereign. As already submitted to your lordships, the learned judges of both the High Court and the Court of Appeal have held unequivocally that the Constitution of Kenya has no eternity clauses and that every clause is amendable. To that extent, a proposal to amend what is amendable cannot be said to be unconstitutional. The effect of insulating Article 89 as an unamendable clause would be to elevate the IEBC above the Constitution and substitute it for the sovereign. It is a trite principle of constitutional interpretation and application, my lords, that constitutional provisions cannot contradict or override one another. In fact, this court has, in the decision of Speaker of the Senate and another versus the AG and others, advisory opinion reference number 2 of 2013, held that a constitution as an embodiment of compromises is by its very nature not a stranger to internal contradictions and conflicts. And what that means is that where such contradictions arise, it would be within the judiciary's remit to interpret and harmonize them as the body with the ultimate power and authority to do so. And this was best illustrated by the Court of Appeal in the case of Attorney General and another versus Andrew Kiplimo Sang, Muge, and 2 others, where the Court of Appeal reconciled their apparent conflict as to the date of the general election under the current Constitution, and thereby underscored the court's authority and duty to interpret and harmonize the conflicts in the Constitution. For these reasons, my lords and my ladies, and those detailed in our submissions, we urge that the Honorable Attorney General's appeal be allowed. I thank you.
My Lady, the Chief Justice, and the Honorable Judges of the Court, with the kind permission, my name is Arnold Ochieng Oginga. I wish to address the Court on 2 key issues, that is issue number 5, as identified by the Honorable Court in its ruling, that encapsulates the twin issues on public participation and the role of IEBC under 2574, and issue number 7, that is on the question of whether a multiple or single question referendum. Just before I begin, let me point out that the question of public participation was addressed by the Court of Appeal judges, and the majority bench of the Court of Appeal agreed with the High Court that there was no public participation. In the judgment, in the majority judgment by the President, that is contained at paragraph 345. Then in the second judgment by Lady Justice Nambuye, that is contained at order number 4 of her ladyship's judgment. Then in the judgment, but by Justice Kiage, that is contained at pages 133 to 134 onwards. And finally, in the judgment by Justice Gatembu, that is contained at paragraph 91 of the learned judge's decision. So that as I begin, my lady and my lords, let me submit first that the English language is not an instrument of mathematical precision. But when it comes to interpreting words and phrases in the Constitution, the courts must give meaning to such words and phrases as intended in the Constitution, my lords. So that in this court's decision, this court has affirmed the concept of a holistic interpretation of our Constitution. So that for that proposition, I refer the court to reference number 1 of 2012, that is in the matter of the Kenya National Commission on Human Rights, where at paragraph 26, this court was emphatic when it pointed out that a holistic interpretation of the Constitution does not mean an unbridled extrapolation of discrete constitutional provisions into each other so as to arrive at a desired result. So that in that context, my lady and my lords, examining the provisions of our Constitution, the court will note that the framers of the Constitution intended to use the phrases in regard to the involvement of the people differently. So that in that context, if you look at Article 10, the language used in our Constitution is participation of the people. Comparing that to Article 89, subclause 7A, the language used in that provision is consult, where it says the Commission shall consult all interested parties. Again, comparing the same to Article 118. First, it will be noted the title to Article 118 is Public Access and Participation. Again, comparing the same, my lady and my lords, to Article 196. Again, the title used is Public Participation, that is within the context of the county assemblies. Again, the language used under Article 174C of our Constitution is participation of the people. Now, it doesn't end there again, my lords and my ladies. If you look at Article 256(2) of the Constitution, the language used is that Parliament shall facilitate public discussion. Again, to compare the same with Article 257, it says, county assemblies, the bill shall be forwarded to the county assemblies for consideration. So that under Chapter 16, the language used is not public participation. Now, the upshot of my submission is that, number 1, public participation within the context of an enactment of legislation cannot be equated to the participation of the people within the constitutional amendment context. Secondly, the courts ought not to use the phrase public participation loosely, because that was not the intention of the framers of the Constitution. Again, third, I submit that the role of public participation and participation of the people under Article 257 is to enable the people make a decision on whether to accept or reject a bill, unlike in the normal legislative process where public participation calls for the inclusion of the principles in the Robert Gakuro case. Now, on that note, I finally submit that the use of the different phrases on the involvement of the people in our Constitution was intentional and was not by mistake, and the framers intended that said phrase to be interpreted as such. Now, the foregoing leads me to the twin question in relation to issue number 2, then how then do you determine whether there has been adequate public participation and participation of the people within the Constitution amendment process? And the answer to that question, my lords and my ladies, lies in the decision by Lady Justice Jamwea, as she then was, that is in the decision of Republic versus County Assembly of Kirinyaga, where her ladyship, at paragraph 56 of that decision, rendered the position that, number 1, the effect or lack of public participation can, however, only be determined upon the conclusion of the process in Article 257. Then her ladyship concludes by pointing out that it may be necessary to consider the cumulative efforts of public participation before deciding on its sufficiency or otherwise. Now, quickly to summarize my points on public participation, my lords, the court will note that the judges did not address their minds on the question of the over 4 million persons who signified their support of the bill at the initial stages. Then number 2, the Court of Appeal in the majority decision erroneously uses Tana River County as a yardstick to measure the extent of public participation. On that point, let me point out that the question of whether or not there was adequate public participation at the county assemblies or the National Assembly, it was not one of the issues that was pleaded in the petition. And at the time of the hearing of the petitions, the process was still ongoing. So that my other submission would be that it was even premature for the courts to draw the conclusion that there was no or there was inadequate public participation, and yet the process had not yet been concluded. Again, it is on record that even the court itself, the judiciary, gave views on the bill and participated in the public participation process. Due to time, my lord, let me conclude by stating I urge the court to uphold and affirm the position so that one germane issue in this appeal that has emerged from the earlier submissions is the question of certainty in law, so that this court in the decision of Albert Chaurembo was emphatic that certainty in law makes for uniformity in the administration of justice and prevents the unbridled discretion of the state organs mandated to perform judicial and quasi-judicial functions. Finally, let me conclude by saying that justice must not only be done, but must be seen to be done, and the courts of law ought not to interpret and apply the law in a manner that would lead to a predetermined outcome, thereby negating already determined precedent on constitutional questions. I beg to rest at that point.
Chief Justice, my ladies and my lords, I have 2 minutes, and I want to make the following point briefly, that the Constitution is not a mental construct. The Constitution is not an academic abstraction. The Constitution is the document the Kenyan people gave themselves to manage their affairs. And Madam Chief Justice and my ladies and my lords, in answer to the question the question of amendability or non-amendability, looking at Article 255, Sub-Article 1, if you my Lord, my Chief Justice, I understand I've been given 5 minutes by the AG. I don't know whether they can confirm that to be the case. Yeah, I was beginning to think how I'll rush over this point, but I'm grateful. In his address earlier, which I wish to associate myself.
Let's get that. You got the 5 minutes from
From the Attorney
Senate.
General.
5 minutes from the Senate.
From the Senate.
Yes.
I'm grateful. My Lord and my ladies, the two decisions by the High Court and the Court of Appeal was a case of usurpation of the sovereignty of the people and a judicial overreach. And I'll state the reasons why I say so. If you look at Article 255, sub-article of the Constitution, and I like the words that my learned friend, Mr. Paul Mwangi, used, and consider which are the sacrosanct provisions of the Constitution. My lords and my ladies, what is more sacrosanct than the supremacy of the Constitution? What is more sacrosanct than the sovereignty of the people? What is more sacrosanct than the Bill of Rights? And yet you find these provisions in Article 255 of the Constitution that makes those provisions amendable, so long as the procedural and constitutional processes under Article 255 to 256 and 257 are undertaken. There used to be an old philosopher in Britain called Samuel Johnson. There was a contest between subjective idealism and realism. And the idealists believed that reality was a mental construct. It was merely a perception. And Samuel Johnson convinced those with whom he was having an argument that if you want to prove that a stone exists, just kick it. Don't involve yourself in an argument whether the stone exists or not. So in this, the question that is before the court is as to whether the impugned provisions of the constitutions are amendable or not amendable. And my ladies and my lords, you'd find under Article 255, sub-article 1, that even the most sacrosanct provisions of the Constitution are amendable so long as you determine which path you follow, whether it is by popular initiative or by parliamentary initiative. I am saying that it is a usurpation of the sovereignty of the people, because it means that any time the people would desire to amend the Constitution, that path will be through a minefield at the time of origination of the process to its conclusion. I think that power, the court should be very careful and exercise judicial restraint, so that in terms of this constitution, which gave sovereignty to the people of Kenya, we do not, that power of the sovereign is not usurped by dint of judicial craft. Now, the other thing that we wanted to point out and is in our submissions, constitutions follow so many paths. If you look at the history of many constitutions, they have come through revolutions, they have come through military coups, they have come through an uprising of the people and so on. But the sovereign in Kenya, the sovereign, which is the people in Kenya, set out clearly that in whatever circumstances they desired to change any provisions of the Constitution, there was a process, a constitutional process, and a constitutional path to achieve that desired end. And therefore, any steps taken prematurely to interfere with the exercise of that sovereign authority, I think that would be a case of judicial overreach. And one would want to look at the history of Kenya, the process of constitution making, that we went through many paths, including the deliberations at Lancaster, including the amendments, including the Constitution making a process through a Constituent Assembly, as it were, the CKRC, and finally, when we came with this Constitution, the path was that the proclamation of this Constitution would be after the people themselves had made a decision through a process that involved the people at every time and instance. And therefore, it would be to rewrite the Constitution, to read into the Constitution what is not in the Constitution. And I think if we take that path, then we obviously will be creating tension. We used to tensions between the executive and the other arms of government, like Parliament or the judiciary, but have a tension between the people and any arm of the government where the people are stopped either by legislation, which goes out of the constitutional remit, or by decisions that stop the people from exercising their right. I think that would be giving ideas to Kenyans to find out another path to reach their desired end in changing the Constitution that, as my learned friend Mr. Rara said at the beginning, by reading the preamble, I think the preamble to this Constitution is very important, that this Constitution is enacted by the people and the people have given this Constitution to themselves. And the powers exercised by all arms of government, including the judiciary, is a delegated authority. Therefore, we would urge the court to allow the two appeals by the Attorney General and the IEBC, and to dismiss the appeal by Mr. Morara Omoke. I thank you.
Thank you very much. There is one party, Philista Wakesho. Our reading of our submissions is that she supports the first and the second appellant, but she appears within the group that was in the High Court called the Third Way Alliance. So we had allocated 1 hour to that group of respondents. So you will have 15 minutes on behalf of Philista Wakesho.
That is correct, Your Ladyship. Actually, yes. I wanted to intimate to the court that I discussed with my colleague Elias Mutuma representing the Third Way Alliance, and we agreed that since he's involved in so many issues, he would take the 45 minutes, then I would utilize the 15 minutes. Okay. So I think that is very correct. Okay. In order, Lady Chief Justice.
Your name, please.
Now, for the records, my name is George Gilbert, Lady Chief Justice, and I appear for the 74th.
Say that again.
My name is George Gilbert.
George Gilbert.
And I appear for the 74th respondent. Now, because of the limited time, Your Lordships, I am going to handle two issues. And number one, it is important to start by stating that I fully support the appeals by the Attorney General. I also fully support the appeal by the IEBC. I disagree with the appeal as filed by Mr. Omoke Morara, my learned colleague. Now, in relation to my support to the appeals, I am more interested in issue number one on the basic structure in terms of my highlighting, and then issue number 7 on the referendum questions. As I start to take it on the basic structure, my lords, it is important that I bring something that I believe is very much important to context before this court. In the case, celebrated case of Kasevenanda. Your Lordship, in this case, there is one important thing that has not been told before this case, which seems to be the leading case in terms of the basic structure. The issues that were in context in that case were issues of land reforms introduced by the state of Kerala in India. laws were introduced by the parliament which sought to alter the rights of private individuals who are large landowners in terms of how they are supposed to manage and utilize their lands. Kasevenanda himself was a head of a monastery, and so thought under Article 26 of the Indian Constitution that he was convinced by a very important jurist in the Indian country to go to court and seek a reprieve that the amendments that were proposed by the parliaments were not in order. The amendments that were proposed by the parliament to change the constitution did not talk only about the land reforms. While the constitution, being interpreted by that government, talked about interpretational change in terms of forming the basic structure of the constitution and saying that that basic structure could not be interfered with, there was another issue in that case known as the directive principles. Directive principles, which is mentioned in Article 36 to 51 of the Indian Constitution. Now, those principles, despite the amendments being omnibus, the court held that those ones are okay, the parliament could amend them. Comparing that with the current situation, the courts in this country, both the High Court and the Court of Appeal, said that everything that was proposed to be amended, they stopped the amendment of everything. And that is where the problem is. Now, when you look at the context of the basic structure, in the Indian Constitution, it emanates from Article 368 of the Indian Constitution, Article 368 of the Indian Constitution. The said article gives power to Parliament to amend those constitutions the way it deems fit. However, insofar as it does not touch the basic structure of the Constitution. In the Kasevenanda case, it was found that what we call the directive principles did not touch the basic structure of the Constitution, and that was said that they could go ahead and amend that. Your Lordship, the directive principles simply talked about issues to do with environmental protection, protection of monuments, and administrative issues. What we are putting in context is that court identified some things and said these ones cannot form the basic structure. Going forward today, do we have those things that consistently a Kenyan can stand up and say, this forms the basic structure and these do not form the basic structure? There lies the confusion and the lack of consistency as submitted by my senior counsel, George Uraro, where he said that in the High Court, the court pronounced itself that basic structure will be decided on a case-to-case basis. When we came to the Court of Appeal, some of the learned judges posited that 255.1, the provisions under Article 255.1, would form what essentially would be the basic structure. Now, if you put that in context, you find a very important confusion that cannot let a Kenyan move forward in terms of constitutional amendment. Now, that brings me to the important case of Kivuitu versus Kivuitu, which is cited by the Attorney General. I think it is in page 142 to 182 of their Volume 2 Bundle of Authorities. Your Ladyship, as I go into that case, it is important that I set out this with precision, that my context of submission in terms of the basic structure is that the Constitution of Kenya has a basic structure, but the principle and the doctrine of basic structure is not applicable. There is a distinction. I submit that the Constitution of Kenya, basic structure is found at Article 255, 1, and they are listed from A to J. Your Ladyship, I will not go into the details because exactly that is exactly what Senior Counsel James Orengo just submitted immediately before he sat down. And he asked this question: what is more important in this country than the supremacy of this Constitution? He also asked you, what is more important in this country than the Bill of Rights? Your Lordship, we submit that there is nothing more important in this Constitution than those listed in Article 255, 1A to J. Your Lordships, I want to adopt the submissions in relation to the physical design and physical architecture of this Constitution. Your Ladyship, the Constitution starts by showing us the preamble, and that preamble, there is something very important on the preamble because it talks about the sovereign, who are the people of Kenya. Then when it leaves the preamble, it goes to the republic, the citizenship, meaning the Constitution as drafted goes step to step with each preceding provision and article feeding into the next one. The finality is that we end at chapter 16, which is the substantive provision of the Constitution, because after that we go to the transitional provisions. And when it gets to chapter 16, now the Constitution considers that we have discussed everything that is important in this Republic of Kenya, but the most important thing is supposed to come. And what is that, Your Ladyship? The most important thing is how to amend this Constitution. To set a very important distinction between this Constitution and the Constitution of India is that, as I said before, their Article 368 finds a twin sister in our Article 256. Because those are the articles that talk about parliamentary initiative. Article 255 of the Constitution of Kenya does not have a twin sister in the Indian Constitution. And there lies the difference. I will adopt the submissions of Senior Counsel George Oraro when he said that when making constitutional interpretation and importing something from another country, you cannot copy-paste that without looking at the exact provision. If it is a twin provision to our country, I submit that Article 255, 1A to J does not exist in the Indian Constitution, and therefore the case of Casavananda does not arise. Your Lordships, I also submit that when this Constitution was created, designed, and crafted, a consideration was made of the developmental stages of constitutional amendments over time. With that, I'll refer you to paragraph 159 of the case of Kivuitu, where this is what the court said. In a country like ours, which has a history of disrespect for the sanctity of the Constitution, the jurisprudence propagated in Joya 2 case was necessary. It goes on to say, this may explain why the people of Kenya, aware of the frequent and the frivolous amendments to the repealed Constitution, provided for Article 255 of the 2010 Constitution. this case was cementing the position that this article was meant to stop what I would call mad amendments of the Constitution, what other people call dismemberment of the Constitution. So that said, you can amend as long as you take it to the referendum if it involves issues that form the basic structure under Article 255 1A-J. You can amend. The case at paragraphs 160, the case goes on to say, Your Lordship, it is clear from the above cited provision, they are referring to provision number 255, that's Article 255, that there are amendments that can only be done with the involvement of the citizens by way of a referendum. And it lists those amendments as 255(1). Popular initiative involving at least 1 million registered voters. Your Ladyship, Your Lords, this Constitution is amendable. I beg you to find a lot of solace and persuasion from those provisions. And I'd like you again to consider what the court in Kivuitu says in paragraph 158 again, where they reiterate the persuasion by Ringera J. in Njoya 2 by holding that an amendment that upsets the basic structure of the Constitution could not be effected by Parliament without involving the people. That's the referendum, Your Ladyship. I close that line of submission to hold that basic structure is not applicable as a doctrine, but the Constitution of Kenya has the basic structure doctrine and can be amended through a referendum by the people. I want to talk about issue number 7 within 1 minute, and I'm sure I'll manage, of the issues raised by the court in terms of the issue of setting of referendum questions. And my line of argument is simply that that issue was not ripe for discussion by both the High Court and the Court of Appeal. I submit that until the IEBC reached that extent to start doing that which they were supposed to do by presenting it to the people, they cannot be faulted, because doing any other thing is judging them based on speculations. And the court of law can only deal with facts before it and not speculations by parties. I rest my submissions and let court adopt the other rest of my written submissions. As filed in court. I have 7 seconds which I donate back to court. Thank you, Your Lordship.
Thank you very much. Is there any other respondent who is supporting the first and the second appellants? Our list shows 254 Hope. The 10th respondent is partially here and there. I don't know.
May it please the Honorable Court, my name is Dr. Eboso, and I was not prepared to be giving my submissions today, but I think I could go ahead and try to beat the time. So, as you rightly put it, 254 Hope does not fully support the appeals by the appellants, neither does it fully oppose We support it to an extent and oppose it to an extent, and we will highlight and we'll be able to demonstrate to what extent we support it and the extent to which we do not support it. I will start with the concept of the basic structure doctrine, which really formed the main part of the entire appeal. And the basic structure doctrine really is an inherent implied provision in the Constitution. The argument by the appellants that the basic structure doctrine appears nowhere in our Constitution is false, for the reason that the basic structure doctrine, in being an implied provision, means you will not see it. You will have to look into the other express provisions in order to pick out an implied provision. And that is not the only implied provision in the Constitution. The issue of separation of powers of state offices, the issue of various other issues really, including even sovereignty of the people, was not mentioned in the older Constitution. And in the case of Njoya, that is what Njoya was saying when he said that it need not be mentioned. It is implied by the very nature of a constitution. In Kesavananda, one of the judges asked, if the parliament is sovereign and can amend any provision of the constitution, can parliament amend the constitution to turn itself into a monarch so that we never have any other elections going forward? And the answer to that is it cannot. And the answer to that comes from the fact that a constitution is not owned by parliament, is not owned by any of the constituted organs. A constitution is a document that is owned by the people or the sovereign. Let's call it owned by the sovereign, who then writes down how he wants their affairs conducted and hands it down to the constituted organs. Therefore, it is unthinkable that a constituted organ would then have absolute power to change even that document, which was not its own document. However, like any other implied provision in any law or contract or constitution, such implied provisions, are limited only by express provisions to their contrary. That is to say, when we have an express provision that seems to limit the extent of application of the basic structure doctrine, then the basic structure doctrine will be limited to that extent of that provision. In our Constitution, we do not have any absolute bar on the application of the basic structure doctrine. And therefore, because it's a constitution and inherently has the limitation on who can change it, then it means that we will only look for any express provision that tends to limit the basic structure doctrine and how it applies in our country. The other reason why the basic structure doctrine must apply in our country is because our Constitution, not out of an abundance of caution, but deliberately asserted that there exists a sovereign in our country, and this sovereign is the people. That therefore means that any other entity that is not the sovereign cannot have absolute power of amendment. So to that extent, it means the basic structure doctrine is applicable. What is the extent of the applicability of the basic structure doctrine? Again, the limitation of the basic structure doctrine lies in the very inherence of the Constitution, in that it has a sovereign. If the basic structure doctrine is applicable, then it cannot be applicable to the sovereign, for the reason that the sovereign can, for the reason that the sovereign is the sovereign. They can amend whatever they want to amend and let be what they want to let be. Still on the basic structure doctrine, in the constitution making context, the sovereign is really regarded as a sovereign and is called the primary constituent power. That is the power to make and remake a constitution. So the dispute that came before the court is really whether, it should not be whether the basic structure doctrine is applicable or not. The basic structure doctrine, by virtue that we have a sovereign, should automatically be applicable. The question should be whether it is the sovereign that was attempting to amend the constitution or not. If it is found to have been the sovereign that was attempting to amend the constitution, then by default, the basic structure doctrine will fail to apply to that extent. And that brings us to the next question of what constitutes the primary constituent power. Now, our Constitution contemplates, first, asserts the sovereignty of the people. Secondly, aside from asserting the sovereignty of the people, it dictates that the sovereignty of the people may be exercised under the Constitution. Now, sovereignty as a concept is an extra-constitutional notion. That is not to mean that it can only be exercised outside the Constitution. It just means that it cannot be limited by the Constitution. And any imposition that it must be exercised outside the Constitution itself is a limitation on sovereignty, which is not possible. Therefore, we have stated in black and white that the sovereignty of the people may be exercised under the Constitution, and in fact, for it to get legitimacy from the Constitution and any of the constituted organs, it has to have been exercised in accordance with the Constitution, and that is Article 1. So Article 1 is not binding the sovereign that they must act under the Constitution. No, it is stating that any of the constituted organs, that is the judiciary, IBC, whatever will be involved in assessing the sovereignty of the people, can only give legitimacy to a form of sovereignty exercised by the people in accordance with the Constitution. So it is not a command to the sovereign, it's a command to the constituted organs, which is really what a constitution is. So it is commanding all of us acting as state organs to not give legitimacy to any exercise of sovereignty, although it is there. Someone mentioned about coups and various forms in which a constitution is changed and various ways in which you can reconstitute government not in accordance with the existing constitution. That can happen because sovereignty cannot be limited by the constitution. It's an extra-constitutional entity. However, that sovereignty can decide that it wishes to be guided, and it will state that any sovereignty that should get legitimacy from this constitution must be done or carried out in accordance with this constitution. And that is the remit of Article 1 as per us. I was on the primary constituent power and what really it entails. The primary constituent power, as I said, is the power to make and remake the Constitution. Again, it's an exercise of sovereignty of some form, and probably the highest as far as constitutional aspects are concerned. And we might want to try and deduce what is the primary constituent power as far as our Constitution is concerned, and that lies in various provisions, but most importantly, aside from the provisions I've talked about, the sovereignty of the people and being exercisable under the Constitution, the preamble tells us the kind of sovereignty that established the Constitution, because there are different levels of sovereignty. When I go to vote, I really do so as a sovereign member of this country, and many other ways in which the people exercise their sovereignty directly. But that alone is not enough to change the Constitution. That me voting alone is not enough to elect the president or to elect a government. The sovereignty is at different levels, and the different levels have to be defined, and that is, I believe, what the Supreme Court is called to do at this point. So the primary constituent power in the preamble, we are told the people, having fully participated in the process of making this constitution, give to ourselves this constitution. And that tells us that the primary constituent power, or the kind of sovereignty that should be adequate to remake or make the constitution, is one which involves the full participation of the people. I believe that's what the High Court was really attempting to bring out when it gave the four-step process of amending the Constitution. Unfortunately, it provided a four-step process that seemed to be grounded on the fact that sovereignty cannot be exercised under the Constitution. And that is where I dispute the decision of the High Court. So what we are going to be looking for under our Constitution, if we are to get the power of amendment that is the primary constituent power under our Constitution, we will be looking for which kind of process or kind of sovereign exercise of power under our Constitution constitutes the full participation of the people. And this takes me to the two modes of amendment of the Constitution. One is a parliamentary initiative and the other is a popular initiative. Now, a validly conducted popular initiative, we believe, is a full, involves the full participation of the people. And this is in contrast to the parliamentary initiative, which is the only other initiative you can amend the Constitution with. One, the parliamentary initiative involves members of parliament, and you will get public participation to a limited extent, but not binding to Parliament. Then finally, we will have a referendum. The appellants argue that that is a full manifestation of the people's sovereignty with full participation, but we dispute that. Why? Because if you look at the process of amending through a popular initiative, it is obviously more participatory of the people. One, a person is going to come up first with the proposal. This is part of the people. He is going, or she is going to have to sell it out to other people, 1 million of them, who have to be voters, which means for them to get 1 million voters, they will have to sell that idea to much, much more than that, a broader population. After that, it will be taken to the county assemblies, which exercise the sovereignty of the people by dint of Article 3, where public participation will take place. They will then go to the next stage of Parliament, where public participation will take place, and Parliament is insulated from vetoing it. So that even if Parliament were to veto it, it will still go to a referendum, which is again participation of the people. That tells you that even if there was adequate participation in the parliamentary process, there is indeed a fuller participation in the popular initiative. And because there's a fuller participation in the popular initiative, it means the parliamentary initiative cannot be full. And that tells us that the parliamentary initiative is still limited by the basic structure doctrine, whether or not it goes to a referendum or not. However, because the Constitution constrains and says that all sovereign power of the people must be exercised in order for it to get legitimacy from any state organ, must be exercised in accordance with the Constitution, then it means that an exercise of sovereign power that is fully participatory under the Constitution, then that power is the primary constituent power. And that is what we are endorsing, that a popular initiative validly conducted constitutes the primary constituent power, which takes us to, was this popular initiative validly conducted? Now, inherent in a constitution again, there is a difficulty in the process of changing it. And that is seen in the fact that a constitution is supposed to maintain the stability of government. We cannot have a constitution where it is changed every other day by whimsical feelings of the time. And constitutions the world over have a procedure that tends to make the process of changing the constitution unlike that of changing any other law, to make it deliberately difficult. And that deliberate difficulty is what is seen in the two processes of amending our constitution. One, the popular initiative. For a member of the public to garner 1 million signatures, valid signatures of registered voters, and then goes through the whole process up to the referendum, means that the process of amending the constitution is difficult. But for a member of the public to raise that, then it means that amendment really was necessary. For a public entity or anyone to pass an amendment through the parliamentary initiative, where Parliament will have to meet twice, the two houses to meet separately twice, 90 days apart, and raise 2/3 majority all the 4 times, and then still have the possible difficulty of the president insisting that this has to go to a referendum, and still have to go to a referendum and convince Kenyans. That tells you there was a deliberate difficulty put there. Now, when the same public entity decides to use public authority to now collect the signatures, to use public resources to propose and promote, it makes the popular initiative defeat the difficulty that was intended. And that is where 254 Hope had a problem with this process. That what was deemed a popular initiative was not really a popular initiative. It was defeating the deliberate difficulty that is in the process of amending our constitution. And therein, that is where the problem with this initiative came in. So had this initiative truly been an initiative by the two persons who initiated it, without any assistance from the state, and without getting any assistance from public authority, except in their private capacities, then this would be a popular initiative. And I'll go to the question of whether the president can initiate a popular initiative. I disagree with the fact that the two lower courts, either deliberately or somehow, refused to differentiate the difference between Mr. Uhuru Kenyatta and President Uhuru Kenyatta in his official capacity. There is no doubt when the person of the president decides to write a check to pay school fees for their daughter or son, there is no doubt whether they are doing it as the president or in their private capacity. Why it becomes a doubt when they gazette a task force, when they do official functions, then we couldn't get it as 254 Hope. We believe that it is very clear, article, not sure if it is 135, which states that a decision of the president shall be in written and signed and with the seal of the president. Once that has been done, then that is, it's presumed that they are doing it in their official capacity. And they cannot turn and claim they were doing it while they enjoy their private rights. The private rights they still enjoy them when they go to vote, when they support a candidate in an election, but they do so in their private capacity, and we never have doubts about that. So the president initiated, or rather proposed, this amendment not in his private capacity but in his official capacity, and that is what made the popular initiative not a popular initiative. Finally, I'd like to go on the question of immunity because it also touches on the separation between the two. We find in our Constitution, in the various provisions, there are two types of immunities that are contemplated. One is immunity from prosecution, or rather immunity from proceeding, and the other is immunity from liability. And you look at various provisions, you'll find that most officials acting in official capacity have been immunized against liability. That is to say that if you feel that this official violated the Constitution and therefore injured you somehow, you can sue this official. The court can find that yes, there was a violation and you can get some remedy, but this remedy will not be held against them personally. That is the immunity from liability. But immunity from proceeding appears in, I think, only two places that I have seen in our Constitution. One is the Constitution itself, in Article 2, I think, which states that no proceeding can go in any state organ questioning the validity of the Constitution. The second place is when we are talking about immunity of the president. And so we can't look at immunity of the president like the usual official immunity that is enjoyed by other state actors. And it's not unusual. Today, I think when we were starting off, the court effectively immunized amishi who participate in the High Court from proceedings subsequent to that in an appeal. Essentially, that was an immunity from proceeding because they can't be named a respondent after they acted as a court. So it's not a concept that is unheard of or that promotes impunity, but it more protects the sanctity, one, of the court, and two, the sanctity of the sovereignty of the republic from embarrassment. And so we are persuaded that the immunity contemplated in Article 143 of the president is unlike other immunities. However, it covers the president as long as they are performing official functions. The argument that the issue of in exercise of powers under the Constitution, therefore, if they are exercising powers that are later found not to have been their powers under the Constitution, then they are liable. I think that's a fallacious argument. For the reason that by the time the president is exercising their powers or powers they think are their powers under the Constitution, they have a duty, which is an official duty, to first make the decision of whether that power is they have it or they don't have it. And they don't do it in their private capacity. They do it as the president. And therefore, one of the functions of the president under the Constitution is really to interpret whether they have the power or they don't have the power. So by saying they will be liable when they make a wrong decision in that determination is essentially saying that the immunity covered there has an exception, which is when they make a decision on whether they have a power under the Constitution or not. Finally, on the same question of immunity, the issue of 143.3, I think the one that freezes time in both civil proceedings and criminal proceedings during the tenure of the president. You would wonder if the president can be sued when they do an unconstitutional thing and proceedings continue. Why would we want to freeze time, therefore, in a civil proceeding against the president? Yet, the president can be sued in his personal capacity for a private matter. Therefore, we wouldn't need the freezing of time. I'd like to quickly go to the issue of quorum of IBC, because I initially had ignored it, but I was surprised that it got here. The issue of quorum, one, the Constitution had an implied quorum of IBC. By dint of article, I forget, the article that talks about the commissions and their composition. The Constitution cannot have anticipated a commission that is unable to function. Therefore, even if Parliament did not exercise their sovereign duty to legislate on quorum, suppose Parliament never legislated on quorum in 2012, are we saying that IBC would never be able to function? That cannot be true. Therefore, that's another implied provision in our Constitution, that there is an implied quorum that was dictated by the Constitution. However, that kind of implied provision really is a provision that Parliament has been given a duty to vary. As I said, implied provisions can be varied by an express pronouncement. And Parliament made an express pronouncement in 2012, making the quorum 5. However, when the law was repealed, now, this brings me to a second issue, which is what happens to a law when it is found to be unconstitutional. One, why was it found to be unconstitutional? Was it substantive or was it procedural? Because if it was procedural, that is, it was not validly enacted, then that law was not there right from the word go. It was never enacted. And anyone who relied on it relied on no law at all. But if it is substantive, that is, the proper procedure was followed, the law was put in our statute books, then that law cannot be rewritten in a court. The courts are supposed to interpret. It can only be disapplied by the court if it is found to be substantively unconstitutional. So the court will have the dispute before it, and it will disapply that law to the extent that it is unconstitutional. But where the court purports to rewrite the statute, what it is essentially doing, and that's why I disagree with IBC for claiming that it should be let go for relying on the court decision that made them to be constitutional. When a court, or say in this case the High Court, purported to rewrite the statute, what it was essentially doing is binding even the Supreme Court, powers which it doesn't have. The High Court should limit, and any court really, should limit itself to the facts before it, the parties before it, and make a declaration on those. It should be the public bodies that make a decision on how they will interpret that order, whether it will be in rem or they will apply it to those factors. And the public body will retain the accountability for such a decision. We must not transfer the responsibility of defending the Constitution, which is upon all of us by dint of Article 3, to the courts, so that when IBC relies on a determination that is later found by maybe another court or a superior court to be unlawful, IBC will hide behind the fact that a High Court had made that determination. It was still IBC's responsibility to determine whether this court order is constitutional, or rather, whether this court order applies to all matters before IBC. And so in this case, I'm essentially claiming that, one, the High Court was not bound by the decision in Biwott and the other decision, and it looked at its facts and made its decision validly. However, the High Court was wrong in assuming that by nullifying the substantive constitution, that the previous court, by nullifying the substantive constitutionality of the statute as was passed in 2017, reverted back to the old statute. No, this remained in the statute books, and it will be upon IBC or any other party who may never have been even in that decision to approach a court on a different set of facts. And if the other court will feel like, no, this statute as applied in this manner, if applied the way IBC was applying it in Biwott, it was unconstitutional. But if applied in another manner, it would be constitutional. And this takes me to the idea of presumption of constitutionality, which, as 254 Hope, while it may not be the substantive core of this matter, as 254 Hope, we've been worried that almost everything that is, the jurisprudence that seems to exist is one where we presume certain acts by states to be by state actors to be unconstitutional until found to be constitutional. And the presumption of constitutionality is not really a common law, just a common law principle. It's in our Constitution, in Article 165, where the court is directed to determine if any action that has been done is inconsistent. It's not being told to determine whether it is consistent. It's being told to determine whether it is inconsistent. That tells you that the Constitution presumes that act to be constitutional first, and then it should be proven to be inconsistent. So, and that is really, and especially when it touches on legislation, because legislation is a bit special in the sense that Article 3 provides that sovereignty of the people is exercised by their elected representatives, who is Parliament and the county assemblies. So before a court determines that a law that has been validly passed to be unconstitutional, surely there should be no other way that law can be read to make it constitutional. And that cannot be known until the facts are brought before a court, claiming that it has been read in this manner or applied in this manner. So I'm asking this court to determine a number of things. One, the sovereignty and the remit of sovereignty and its exercise under our Constitution. Two, how implied concepts, because when the Court of Appeal made the determination of the basic structure doctrine, I had a headache trying to ask myself, is the basic structure doctrine part of our Constitution then? And can it be amended itself? And it's only recently that I came to the conclusion, yes, it is, as an implied provision. And because it's an implied provision that is inherent, it may not be legislated on. The same way the implied provision on quorum in the Constitution exists, but that, in my opinion, can be legislated upon without necessarily contravening the Constitution. So the remit of implied provisions of the Constitution, to how should courts be interpreting when we come to implied provisions of the Constitution, and what kind of limits should be put on violations of implied provisions of the Constitution. Finally, on immunity, I'd like the court to also determine the issue of immunity against proceedings and immunity against immunity from liability, to draw that distinction, and the exercise of power by state actors. I don't really believe that any state actor ceases to enjoy their private rights because they're in public capacity. No. It's just that public offices don't enjoy personal rights. And it's very easy to distinguish between private actions and public actions because resources follow one and they don't follow another. Public resources, that is. Finally, on the issue of legislation and the validity and invalidity based on constitutionality, because I'm a doctor, I'll give an example of Queen Mary, that is normally known as Bloody Mary. Bloody Mary had tried to conceive for many years, but couldn't. In 1555, she was announced to be pregnant, and her tummy started increasing. And when the time for delivery came, no baby came. And long before we had ultrasounds, what would happen is a patient would be taken for cesarean section to extract the baby who's due and is delaying. And then when you'd extract the baby, you would find that this was a fibroid, not a baby. Alternatively, you might find that this is a dead baby. A dead baby is not a fibroid, it's still a baby. So a statute that has been validly passed, only that it has been found to not be consistent with the Constitution, is akin to a baby that has been validly conceived, gone through the 9 months, delivered, but found not to be consistent with life, and they died. And if later a doctor comes, another doctor with a different opinion comes and listens to the heart rate and says, no, this baby is not dead, this baby is actually alive, we will not go burying the baby and claim that, that the baby was born dead. No. So a fibroid is not a baby. A fibroid was never conceived, did not go through the 9 months, and therefore is not a baby. But validly passed legislation is a baby that needs the rights of a baby. Thank you very much.
Thank you very much, Dr. I think you have put your arguments very powerfully and passionately, and left us with the questions to decide what we have, whether it's a fibroid or a dead body. That said, I think we would like to stop the proceedings for today now, but before we do so, we would like to see where we are starting tomorrow. We would like to know who else is supporting the first and the second applicants. And I see Senior Counsel Mr. Gatonya. I
Yes.
don't know. Yes.
Yes, my lady, we will be supporting the appeal by the Attorney General.
Okay.
Yes.
And Isaac Arwoche. Sorry.
Your Honor, mine is mixed, partially in support, partially in opposition. So I'll probably go after the President's team.
We'll adjourn and convene tomorrow morning at 9. We'll begin with the 20th respondent, and then I think the 19th respondent, Mr. Aruoche. Then we'll go to the third appellant, and then the main respondents and those respondents who are supporting the third appellant. Have a very nice evening.